So let's start with a very simple question. Why should we care about bail? For most people, when we are talking about bail, bail is just a legal term, something they associate with crime shows or newspaper headline. But when we are talking about the advocates, the lawyers, and the law students, bail is not just another legal term. It is something which is closely associated with the personal liberty, which is again the fundamental right of a person in which they remain free unless proven guilty. So, in today's webinar, we are going to decode these guidelines of bail, understand the real world impact, challenges, and judicial changes with our esteemed guest of the day. So, whether you are a law student, you are an advocate, you are a lawyer, or just a citizen interested in understanding the civil liberties, this conversation is definitely for you. So, once again, I welcome all of you on behalf of Law Learning Bench. I encourage you to listen actively, note down your question, drop them down in Q&A section of the chat. Some housekeeping rules are also there, which I want to quickly discuss with all of you. So, first of all, please maintain the decorum of the session. Please respectfully put down your questions in Q&A section and help us utilize this 1 hour in the best possible manner. Apart from that, the meeting will be recorded for training and educational purposes, and any sort of redistribution of any content of this session is strictly prohibited by the organization. So, now, with the understanding of the theme and Law Learning Bench, let me introduce you all to our esteemed guest of the day. So, we have today Swarnendu Chatterjee, sir, who is an advocate on record at the Supreme Court of India, and he brings with himself over 12 years of extensive experience in both domestic and international litigation and arbitration. His background includes working with prestigious law firms where he has advised on diverse legal matters such as constitutional law, insolvency, banking, commercial disputes, and white collar crimes. Swanendu sir is also a very familiar presence in the Supreme Court and various high courts. He has been recognized for his profound expertise in dispute resolution and insolvency law. And beyond his practice, he is an award winning lawyer and a highly sought after speaker and a very dedicated legal educator. Thank you so much, Swanendu sir, for being with us here today. What do you know?
Thank you, Richa. So we talk about today. Richa, it's echoing. Now it's okay. So we talk about today about a very well-known phenomena where we have heard many speakers, including the former Chief Justice of India in Saurav Dwivedi's show few days back, the Lallan Talk, that bail is the rule and jail is an exception. Are we obliviating the rule? Are we obliterating the rule? Or it is becoming opaque? Or it is only for a few people and others remain to languish in jail for political prisoners, for social activists? What is the rule like? So here, this this rule, bail is the rule and jail is the exception. This is a rule which has been taken over, and which is the norm of the day. Rather, it is the principle it is the principle which follows. So therefore, we must all acknowledge this fact that normally bail is the rule and jail is the exception. Unless and until it is required, you should not be taken into custody. Of course, this is the norm for for normal things. For exceptional things like, let's say, murder or any bodily injury or any heinous crime, obviously if you are if you have a threat perception to the society, then individual liberty is trumped over, and jail and or custody is the only thing which you have. And another thing is that for petty offenses like 138 offenses or documentary fraud or something like economic offenses, where bail conditions may be stringent, but they should be granted bail and put to strict terms and conditions, because the conditions of our jails is not very prudent, or they are overcrowded, and the sanitation systems, the water systems, they are quite obvious and but natural, they are not so good. But we can and also we have heard about atrocities in jail. We have seen documentaries also, some atrocities in jail. And we have also read few days back Sunil Gupta, former Tihar administrator of Tihar jail, how nightmarish it can get in a jail. subject to certain conditions, skirmishes and all, which can leave a mark in the mind. So therefore, today we will see how it is a rule for some, exception for the rest, and how this rule has been interpreted by the courts over the years, and especially in this judgment. Why this judgment came about? What was the need and necessity for this judgment to come? Okay, next slide. You see, the occupancy rate in prison. One should always see that the occupancy rate in the prison. The occupancy rate in the prison, you see that for under trials, it is close to, if 100% is the capacity, then you have 80%, close to 80% prisoners are under trials, whose trials are not getting over. And occupancy percentage is more than 100, close to 120, more than 120%, close to 130%. So 100, beyond 100% capacity, it is going. So it's overcrowded. And the conditions, let me tell you, are not great. Some things, though we have judgments from Supreme Court, like in the degrading humanitarian conditions in jail, Supreme Court has given so more to directions, but still they have to be independent and implemented. Sorry, and jail becomes a jail. Jail is not a house, so you do not expect European conditions or conditions from abroad to be implemented that the jail conditions improve. Jail is always a jail where you get mentally derailed. But of course, you are not there for, people don't put you in jail for fun or merry. There can be political skirmishes, but there is always a reason for the same. So the court says that unless and until it is too urgent and too prudent, you need not put somebody behind bars. Okay. What is bail? Now, bail comes from the French word bailier, means to deliver or hand over. Section 2(1) of BNSS, that's the new code, penal code. Bail means release of a person accused of or suspected of commission of an offense from the custody of law upon certain conditions imposed by an officer or court on execution of such a person by a bond or bail bond. There may be a personal bond, there may be a bail bond. So you have heard about bonds and sureties. So there are, when persons get enlarged on bail, it is called enlarging on bail, because they are handed over or they're delivered, and they are said that you keep a surety, a person who will stand as a surety, that if this person does anything else, then I stand as a surety that I'll hand him over. And there are bail bonds, like you sign up, you have to sign a bond and give monetary surety also, like, or if you have an asset, you have to give an asset, something to show that you have deep roots in the society and will not just fly away. Types of bail. Now there are different types of bail. Regular bail, a person has been behind bars for some time, 2 months, 3 months, 1 year, 6 months, 2 years, 3 years, something like that. Then you can go for regular bail. That is called a regular bail, where you are in custody and you are let off from custody. Anticipatory bail. Anticipatory bail is, you need not be arrested. You are on anticipatory bail. You need not be arrested. So therefore, your custody is not required. You file an anticipatory bail. Then you file an interim bail. Then you file a provisional bail. Interim bail means, suppose you challenge your arrest and the High Court says, okay, fine, I'll give you interim bail, or interim anticipatory bail, interim protection. That is also called interim bail. Provisional bail. Now thereafter comes transit bail. Now for transit bail, the thing is that, suppose if one is residing in the state, let's say Madhya Pradesh, and let's say in Gwalior. Now what happens is Delhi police or any other state's police wants to arrest you. Then they have to take transit remand or transit bail. After bail, it is called remand. After arrest, it is called remand. You take a remand from the judicial magistrate. So it is called duty magistrate who gives you a remand. So for any other state, now police is a state law and order law and order situation or a state subject. That it differs from it comes under the home ministry of the particular state. So for it is not allowed for any other state police without permission and without informing to walk into another state and arrest that person. It is not and without taking a remand, you cannot do that and show him arrested. So I handled a case where the person was arrested somewhere in UP and brought to CR Park, New Delhi. The thana or the police station was CR Park. Though he was arrested, let's say today 5 o'clock, he was shown to be arrested at tomorrow 9 o'clock in the evening. Sorry. So therefore, I challenged the arrest and said that how can this be done? You have not taken transit remand. There was an option for me to get transit bail. You did not avail. You did not let me avail. It is a avail that opportunity. It is a derailment of my statutory rights, infringement of my fundamental right to liberty, and you did not follow procedural liberty. So the court understood, and the court said no. You told the police and the state you did not do the right thing, and gave me interim bail, which was finally confirmed. So therefore, so therefore, you must keep in mind that transit bails or transit anticipatory bails are only given by the High Court. So as to enable the thing is that if you show a prima facie case, it gives you that option. Okay, I'll give you transit bail or transit anticipatory bail, so that you are not taken into remand from this state, and you have certain amount of time to go to the jurisdictional high court or disorder sessions to take regular bail. There you have default bail, 167 to CRPC and 187 BNSS. It means that you have been in custody, but the investigation is not over, and the charge sheet has not been filed. So therefore, you are mandated to get bail because you cannot be kept behind bars despite non-completion of investigation. So therefore, it is called statutory bail, which is normally allowed. Medical bail, if you are under typical medical conditions where you have to be treated outside. For example, like Varavara Rao, Stan Swami, and all those people who had Satyendra Jain who had to opt for medical bail. Then bail under special laws, where there is a statutory presumption of mens rea. So you have Section 45 PMLA and Section 37 NDPS Act, which gives you the rigor. Yesterday only Supreme Court had commented upon a Calcutta High Court bench which given a anticipatory bail to in an NDPS case, which says that in NDPS anticipatory is very rare given the rigors of Section 30, given the rigors of Section 37, which acts as a statutory bar to anticipate to and grant of anticipatory bails. Section 37 is obviously of NDPS Act acts as a rigor or a clamp on free flow of liberty because there is a statutory presumption of mens rea that you have committed the offense. It's the other way around. It is guilty until proven innocent, not innocent until proven guilty, which is the norm for any other criminal offense. So in statutory offenses like UAPA, PMLA, NDPS, or erstwhile TADA, it was a statutory presumption of mens rea. Okay. Medical bail recent case. Supreme Court in September 2005 had given Mahesh Raut, the Elgar Parishad case, a convict, medical bail. Then Renuka Swami murder case, the convicts were given The accused were given medical bails. Medical bail is only an exception when Supreme Court emphasized that there are exceptional situations like medical condition is extremely serious. Custody, jail hospitals cannot accommodate such treatment, and facilities are not available in jail, so the person's life is more important. For example, in Elgar Parishad's case or in Bhima Koregaon Elgar Parishad's case, Varavara Rao was given medical bail by High Court in for 6 months, which was later extended. Satyendra Jain was given medical bail for some months before he was got regular bail. So medical bail is an exception which is given when you have extreme medical conditions, or some operation is needs to be done for which you have to be outside. Okay. Bail under special laws. You see, under PMLA, the first thing which started, like, see, Section 45, where there were always the twin test. What was the twin test? The twin test was that you have to show that you are you that the pro that the evidence against you is wrong, is not prima facie. He has to prima facie show that he is not guilty of the offense. So the degree is very high, and he is not likely to commit such an offense while on bail. So it is the other way around. You have to show that you are prima facie not guilty of that offense. So there should you have to comment on the evidence part. So this the Supreme Court found in 2018, speaking through Justice Nariman, that such a condition obviously gives, it comments. Court has to comment on the trial. It is a mini trial. So it is obviously an antithesis to Article 21 of the Constitution, where the bail court makes a roving inquiry and comments on the evidence. So therefore, once the High Court comments on the evidence, or the Supreme Court comments on the evidence, then it is very difficult for somebody to have a fair trial. So it is against the mandate of Article 21. Hence, the twin conditions were declared unconstitutional in the judgment of Nikesh Tarachand Shah. But the government did not bend back. Government said, okay, they reenacted certain provisions with small tweaks and reintroduced the similar provisions again. So again, they were challenged in Vijay Madallal Chaudhary, where it went before a different three-judge bench with Justice Khanvilkar leading, but this time they upheld the up, they upheld the amendment and said that there is nothing wrong, although a review petition is pending, and the court is primarily satisfied on 2-3 counts. We have to wait for Vijay Madallal Chaudhary original judgment to be scrutinized and seen and to be heard by the review bench. Okay. Under special laws like NDPS, you will see that the sensational case of Sushant Singh Rajput's case, where Riya Chakravarti, the actress,
Sir, sorry to
got.
interrupt you. Sir, you are not visible actually right now.
Okay, 1 second.
Now visible, sir. Now visible.
Okay, now it is visible.
Yes, sir, you are visible now. Yeah.
So Riya Chakravarti's case, one had all seen that how things manifolded, and she was taken into custody by NCB, that is the Narcotics Control Bureau. So the accusation was that you are harboring or financing somebody's drug use. Whether 27A or Section 37 falls under the definition of harboring or financing. But bail was granted due to lack of evidence. Lack of evidence regarding that centigrade or having harboring on the accusation of harboring. Bombay High Court granted bail, finding that this is not harboring. They commented on the legal position, NCB came to the Supreme Court, although they did not press for the SLP. They said that please make it clear that this will not act as a precedent. So the Supreme Court clarified that this will not act as a precedent for anything. Aryan Khan bail was granted because everybody knows that he was arrested from the ship, and Samir Wankhede and all those things. Now a Bollywood soap is on that on Netflix. So you see that when the principle of law was there was no drug recovery, there was no strong evidence of conspiracy, and the WhatsApp chats and voluntary statements were much older. So therefore, it was very difficult to label the person as a drug mafia or to keep him under the behind bars under the strict conditions of Section 37. Hence, bail was granted, and thereafter he was given a clean chit. This is one thing on the bail jurisprudence. Now, on the trial jurisprudence, in NDPS cases, you have Tofan Singh versus State of Tamil Nadu, where the three-judge bench of Supreme Court, in 2:1 majority, says that police officers under the NCB officers are police officers, and confessions recorded to them are inadmissible, cannot be the sole basis for conviction or bail denial. So, so they said confessions are inadmissible. So the confessions cannot be brought under the rigor of Section 37 and cannot be asked to give bail, or cannot be the sole basis for conviction. So therefore, it can result in acquittal also. Okay. Article 21. Article 21 of the Constitution says that no person shall be deprived of his life and personal liberty except in accordance with the procedure established by law. Because now, what is procedure established by law? Procedure established by law means there is a legislation which gives procedural safeguards as to how things should be done, how procedure should be followed. In that, it shall be taken into consideration as to how things are to be done, how people have to be taken into custody, or what is to be done. Like for example, in Puttaswamy's case, they said that barging they overruled Kharak Singh's case because they said there is no their procedure established by law is not being followed, and hence it is unconstitutional. So therefore, life is equal to more than mere existence. It includes dignity and equality and quality of life. Procedure established by law must be fair, just, and reasonable. Personal liberty gives protection from arbitrary arrest, right to privacy, legal aid, and fair and speedy trial. Fair and speedy trial, for fair and speedy trial, you have Husainara Khatun. Arbitrary arrest, you have Pravir Purkais. We'll all discuss that. Okay. Now, latest there are many cases which you can come across where the court comments that there is delay in trial, low conviction rate. So Arvind Kejriwal was one, Manish Sisodia was one, K. Kavita was one, where delay in trial and no and well, delay in trial and non-presumption. These were the two were major grounds in Manish Sisodia and Arvind Kejriwal. Of course, these were grounds. One was kept behind bars for 11 months, one behind more than 1.5 years. So therefore, it was in Arvind Kejriwal's case, Supreme Court, Justice Suryakant granted bail, emphasizing prolonged incarceration is unjust deprivation of personal liberty. The court questioned the necessity and timing of Kejriwal's arrest, terming it as insurance arrest meant to keep him incarcerated despite lack of urgency in investigation, highlighted how trials and investigations often suffer from significant delay impacting liberty rights adversely. In K. Kavita judgment, the Supreme Court said that working women do not classify under the women, exception of women, which is women and infirm and old, and which is given as an exception under Section 45 or conditions of bail. So in K. Kavita judgment, Supreme Court criticized the High Court for differentiating on that count and also said that there is no evidence or there is hardly any evidence where corruption and money laundering cases, highlighting that excessive delay and weak prosecution due to low conviction rates leads to unjust detention of accused persons, underlying the need for judicial oversight to expedite trials and protect liberties.
Sir, you are not visible again. Can you please shift the angle, sir? You are actually not visible. You can shift the angle of the system, sir. That will allow us to, have a clear view.
I'm not visible still.
You are visible, sir, but very like short angle. So yeah, when you are like this, sir, then you are a bit more visible. So that was the thing, sir. If you can shift the system accordingly, if it is
That's
possible, sir.
that's okay.
Okay, sir.
Okay. 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 So this judgments, these are the judgments which emphasize on the fact. Even Senthil Balaji's case was on delay in trial. Enormous. There are 360. There are 300. And there are 360 witnesses. The charge sheet runs into thousands of pages. The Supreme Court latest made a comment that you probably need a cricket stadium to complete Senthil Balaji's trial. They also know that it is impossible to conduct the trial in such case. So therefore, they are more or less on the issue that uh, how to make it seem to be fair. So this is the case. Okay. Now challenging the arrest procedure of arrest is very important. How do you challenge the arrest? And suppose the arrest is not in accordance with law. Your Article 21 is at stake. You file a writ petition in the High Court. What will be the thing? Non-disclosure of the grounds of arrest. For what you have been arrested. Grounds of arrest means what grounds? What are the reasons to believe? What are the grounds that you have likely to have committed an offense? So grounds of arrest. Procedural violations. Your lawyer has not been involved. You did not get legal aid. This, that. Remand orders are based on illegal arrest. Failure to inform relatives and nominated person. Okay. Legal and constitutional foundations. Now, statutory bail provisions are there, 167(2) and all. And also there are other provisions which say that if you have served one third or one half of the sentence, then you are likely to get bail under Section 436A of Code of Criminal Procedure Code. Now thereafter, thereafter due to Arnesh Kumar and all, the Arnesh Kumar in 2014 gave the judicial ruling that for offenses which carry seven sentences of 7 years or below, then you cannot be arrested as a matter of routine. You can be given a you can you can be given a notice of joining investigation. If you join investigation, then you did not be arrested. So therefore, and latest Supreme Court has said that you cannot be given 41A or Section 35 notice over WhatsApp. You have to be properly emailed or you have to be served. So therefore, these are some safeguards. And you have presumption of innocence until proven guilty. And this all comes and flows from the ground norm, which is the Constitution of India, which is under Article 21 of the Constitution, which is the divine intervention. You say that which has been framed under the divine law of jurisprudence. You see, it is the heart of the Constitution, soul of Constitution being Article 32, Article 21 being one of the heart of the Constitution. Okay. Now coming to this judgment, Satinder Antil versus CBI. Now the concern before Supreme Court was rising number of under trial prisoners in India, no specific legislation of bail, misuse of arrest powers by investigating agencies, and structured framework and the need for a structured framework for granting bail. These were the rising concerns. which gave rise to this judgment. What are the core principles of the judgment? Core principles of the judgment is bail is the rule, jail is the exception. Arrest should not be routine but must be necessary. Triple test for bail consideration: risk of there should not be risk of absconding, interference with investigation, and gravity of offense. Obviously, gravity of offense, like for a person who has done documentary fraud, or a person who has committed murder or double murder. What happened?
Nothing, sir. You can continue.
Okay, those are not of the on the same platform. Like a person who has committed rape, grievous rape, gang rape, or something like that, and there are persons who have done like PML offenses. So there are money laundering. Although money laundering is a grievous offense, but ultimately it's an economic offense. So documentary or monetary trail. So those are not to be treated. The gravity of the offense may be great, but not of the highest degree where a person has died. Investigating agency's duty under section 41 and 41A. So you have to, so if you are not, if the offense is 7 years or below, you have to be given notice. And if you join investigation and you are cooperating, then you cannot be arrested. Speedy decision. Nowadays, Supreme Court has mandated 2 months for grant for deciding bail applications. And also one should consider the socio-economic background of the accused. If he's the sole breadwinner, if he's the sole person who should be who is there to provide for his daughters or children, or parents, inform parents, then obviously socio-economic background is much more important, or rather you can say a mitigating factor for grant of bail. Now, this judgment classifies offences into four parts. One, which is offences which are punishable with 7 years or less. They say you need not be arrested as a matter of routine, and even if you are not arrested throughout the period of investigation, so upon presentation of charge sheet, you need not be arrested. Then offences with death, life imprisonment, or more than 7 years, of course, you have. Then comes 436A in this category B, that you have suppose stayed for 5 years, 10 years, 15 years. Then obviously your chance of getting bail gets more. Then category C, offences under special acts, NDPS or PMLA. You have to satisfy the twin conditions of the statutory conditions which have been laid down for grant of bail. Then you have economic offences not under special statutes. Economic offenders who ultimately 420 and 406, but recently Supreme Court has said that 406 cannot travel in the same boat as that of 420, so it has to be 420, 120B and all those things. So these are the major classification of offenses, and also it classifies offenses with that of post conviction bail, that is 389 CRPC. So there the Supreme Court says it is completely different. So in procedural guidelines and safeguards, you have notice of appearance under Section 35 BNSS, which was Section 41A. More or less a non custodial route where it is possible. Interim bail and hearing timelines. Of course, now the Supreme Court has mandated 2 months. Time limits for investigation and filing of charge sheet. It is normally 90 days to 180 days. Role of courts and ensuring compliance. Of course, non compliance will get result in bail or acquittal. It is there. Okay. Challenges in implementation. Sometimes magistrates they themselves don't know. Sometimes non-awareness of the judge, misinterpretations by the judge, non-awareness to the Supreme Court or the High Court judgments, lack of training. Then there are delays. Bail applications are kept pending for 2 months, 3 months, 6 months. Then you have social impact, the costs of bail, sureties. You have to pay lawyer fees, arrange for sureties. You see, Christian Michel, Augusta Westland, has been granted bail but still in jail. Why? Because he cannot arrange a surety. There are many such offenders who has nobody, but they are still in jail. They have been granted bail but still in jail because they cannot have a surety, or a person who can stand bail or give bail bond, stand as a surety. Then you have stringent acts where there's statutory presumption of mens rea, where it is extremely difficult to get bail, like UAPA, PMLA, TADA, and all those acts, NDPS. Yes, recent Supreme Court observations about non-compliance or directions to high courts. High courts ordered for the training of magistrates and personal prioritization of personal liberty cases. So it is very important. All these things are highlighted by the Supreme Court, and Supreme Court has highlighted latest many such instances where judicial officers have been sent for training, or younger judges have been made to sit with elder judges. Yes. Supreme Court judgments like in Pravir Purkayastha and Pankaj Bansal's case, it held that the grounds of arrest, all written or not written, it should be conveyed. Now thereafter, oral reading out is insufficient if you do not give, and the prosecutor and the defense attorney must have it with the proper time, at least 2 hours or 1 hour. Thereafter, there are procedural safeguards which now apply to arrest under PMLA and other statutes. Supreme Court's insistence on fair play and due process are arbitrary. Against curbs arbitrary use of arrest powers. We saw in the case of Arnab Manoranjan Goswami's case and Amish Devgan's case how Supreme Court has, and in Ranbir Ranawadia's case how Supreme Court stepped in, and in also the professor's case, Professor Mohammad's case, where Supreme Court stepped in to curb the illegal arrest. Yes. Okay.
So, participants, if you want to post some questions for sir, he is open for the questions now. Sir, you can take a 2 minute break. Meanwhile, everyone else is just posting their questions, sir.
Okay.
Okay, thank you, sir. Please post your questions in Q&A sections. Okay, we have got one question. And sir, are you on break?
Yeah, please.
Yeah, sir. So the question is saying that, hello, sir, do you think that practicing in criminal matters is a good idea for young advocates? This comes from the point that criminal jurisprudence in India is developed, but judges are stringent in granting bail, even though it is the rule. There is difficulty in separating bail from trial.
So, what is the question?
Just give me a second. I am posting the question for you, sir. Yes, sir. You can see in the message box. Visible to you, sir?
Where is the message box?
Sir, DM, in call messages, DM. So basically, they are asking that in criminal jurisprudence in India, which is developed now, but judges are still stringent in granting bail, even though it is the rule.
Okay, I saw the question. Hello, sir. Do you think that practicing in criminal matters is a good idea for a young what later? For a young professional, I take it. And this comes from the point that the criminal jurisprudence in India is developed, but judges are stringent in granting bail, even though it is a rule. There is difficulty in separating bail from trial. You are absolutely right. Bails nowadays have converted itself into a mini trial because people are incarcerated for a long time, and people are incarcerated for a long time, and ultimately once the bail is given, now thereafter the trial does not progress, and ultimately it culminates into the fact that the person is not convicted. You see the commonwealth scam, that trial is not yet over, that trial is going on. So Suresh Kalmati still is a suspect but not a convict. So it takes years. So therefore, you are right that it is not because that the criminal jurisprudence is fully developed. It is still developing on some sense. Still, new fresh air is getting into it. But of course, criminal law is a good area to practice. Even if you are a fresh graduate or a seasoned graduate, doesn't matter. You should, if you are passionate. Main thing is passion. Being passionate and and enthusiastic is the key to take up any challenge.
So there is another question as
Yes,
well.
I'm practicing. I don't want to know if I'm appearing. What is the first thing judge will expect to establish? See, in a bail matter, you will be asked to establish on reading from the FIR that whether prima facie the offence has been committed, and if the person is in custody, and if there is, and if for long, what is the he will see the case diary and see like what is the link between the offence and the offender, and whether prima facie link can be established. Like for example, it's a dacoity case. Whether there are CCTV footages, whether there are CDRs, whether the people have been identified, whether there were weapons. So all these things have to be kept in mind. Basically, you have to detach the link between the crime committed and the accused.
So another question is visible to
If
you.
the first bail application is rejected by the High Court, no new ground. How much time? How you, sir? You have a new ground, like if you have a, if the bail application is dismissed, and next you have to have change of circumstance, like charge sheet has been filed or witnesses have been examined, but delay in trial. Then you have to try all these grounds fresh. But there is to be substantial amounts, like substantial time. Sorry, not amount, substantial time. Like today, it is getting dismissed at least 3-4 months or 5 months minimum. Again, if please suggest, if I'm drafting bail application for my client, what is the basic fact and documents? If the FIR coming, if you should collect the FIR, then you have to show the papers. Then you have to show, then you have to narrate. Basically, you have to ask the client that what is the fact situation, if he's really into that, or what was the what, everything will have a missing link. So you have to search for the missing link. Basically, papers he will require is the FIR, the arrest memo, the seizure list, the people who have been there, or what is the medical, if there is a medical record, then the medical record. So it will depend on fact. It will depend on the specific facts and circumstances. Yes, section for twin conditions are justified in the largest. It is, see, if you are, if twin conditions with reasoning given in Nikesh Tarachand Shah has been kept intact in the amendment, and Vijay Madallal Chaudhary fails on that account, and it goes much beyond. So I believe if you are proving at the stage of bail that you have not committed the offense, then it is something which is very and people use that tool. Investigating agencies use that tool to deny bail. So, in the interest of the society, nothing is in the interest of the society. You see, there are also financial frauds in other countries. How many people do? How many people are incarcerated for 3 years, 4 years, 5 years, 6 years? When the PMLA conviction rate is only 18% or 15%. This answers your question. You can move the second bail application without any new grounds, but it will get rejected. Otherwise, you have to move it under after a substantial period of time.
There's one more question, sir, that I just posted from Q&A. I hope it is
Yes,
visible.
why on the same grounds, one high court? Yes, you can have the same judge rejecting or allowing the bail. Well, like morning he allows on the same ground, evening he rejects. It can happen. So that is why you have an higher court where uniformity can be taken, but there should not be distinguishing factors. No, once in judicial custody, you can file bail if the person is really not into the crime, or else you can you can wait for the charge sheet to be filed. If they don't file a charge sheet, then move a statutory bail. Then you can move a statutory bail. So If the court says no, fine, but there are prime witnesses which have to be examined, then you can ask for a specific time frame in which the witnesses can be examined. Like you take a prayer, you make a prayer that liberty to renew my prayer after 6 months or 1 year.
There are just few more questions that if you
Why
want to
the court? Why the
answer.
now next is why the court granting bail mentioned in the order? This can't be used in the precedent. No, not as a precedent. See, bail orders may not be used as a precedent, but parity may be a ground. Always. The principle of law is there. It depends on case to case. Judges are not particular about person to person, but case to case.
So this was all about today's session, and right now we are in the time of wrapping up the session. So thank you so much, everyone, for being part of today's insightful session. On behalf of Law Learning Bench, I extend my heartfelt gratitude to our esteemed guest, Advocate on Record, Mr. Swarnendu Chatterjee, sir, for sharing his valuable knowledge and perspective on such a significant topic, which is liberty or jail. Sir, your expertise and clarity have truly enriched this session and have provided us a very good clarity on understanding of bail jurisprudence and its deep connection with personal liberty. And a big thank you to all the participants who have actively engaged, have given us thoughtful questions, and shown enthusiasm throughout the session. Your curiosity and commitment has truly made this session and this discussion meaningful. So, at Law Learning Page, we are committed to provide you and equip you with practical advocacy skill and in-depth legal knowledge. We hope today's conversation has not only deepened your understanding of bail and liberty, but has also inspired you to explore these issues further in your legal journey. We look forward to welcoming you again in our upcoming sessions. Until then, keep learning, keep questioning, and keep growing. Thank you so much, and have a very wonderful day ahead. Thank you so much, sir.
Thank you.